All right. Hey, everyone. It's John again. I'm here today with Michael Quinn from Vetter Price. Mike is he's a securities lawyer who's very familiar with a lot of the issues around obviously like publishers, disclosures, things like that. And I wanted to, thanks for being here first off, Mike.
Absolutely.
The thing that I wanted to, the reason I wanted to have this conversation is we did have a case recently where an employee of a publisher had taken compensation and then without disclosing it to the publisher recommended somehow it was involved in recommending the securities then in the publication. The SEC found them out. The publisher fortunately wasn't named because they were not, in my understanding, it was not involved. They were unaware of it, but the employee was named. And I thought that'd be a great reason to kind of talk about like all these issues around securities, disclosures, publishers, and get people a little more educated about what are the risks and kind of outlines of what they need to be thinking about.
Yeah, sure. To me, I sort of look at that as this is just sort of the latest twist, right, on this similar theme that we've been dealing with for decades, right? When I was at the S.E.C. at the end of '98. Around there. And I think when I started at the S.E.C. was right out of law school in '98. And the very first case I ever had was a publisher's disclosure case.
Really?
As part of a sweep. So the S.E.C. sometimes does sweep where they investigate a bunch of different instances of a particular issue and bring all the cases on one day so that they can make a big splash and draw attention to a particular issue. And it was their very first so-called 17B sweep about people that were recommending stocks without disclosing them compensation. And so the very first case I ever had at the SEC involved those issues. And then as it turns out, I end up in this space and I have all these securities publishing clients. And 25 years later, I'm advising on the same issues. And there's always a little twist to it, right? And there's a new way of doing it and things like that. But it's interesting that it's really the same issue we've been dealing with for decades.
Yeah, and I guess maybe that's where we start then is what's the core issue that there's all these twists and turns, but what is the core issue that the SEC is concerned about and that they're obviously very actively prosecuting with people?
Really, the first and foremost, it's disclosure of compensation, right? If the publisher, and sort of for our purposes here, and this sort of intersects with that recent case you were referring to, which is the Makula case, the publisher includes the company, its owners, right? Its employees. And so, a publisher sort of needs, if you're going to have a significant number of employees, you have some responsibility for knowing what they're doing, right? And so you have to have a set of procedures in place and a set of policies in place at the company that require disclosure of, hey, if anybody owns stock in any company that we're publishing about, we need to know about that. Secondly, if anybody has accepted compensation from any company about who we're going to recommend, or somebody affiliated with a company that we're going to recommend, some intermediary, et cetera, so you have to have sort of policies in place to figure out who has received what. But ultimately what that comes down, because all of those people will be engulfed within the definition of the publisher. And the biggest issue for the SEC has a publisher been paid to recommend a security under Section 17B of the Securities Act of 1933, you must disclose that you've been compensated and the amount of that compensation. And so that's really the primary issue that they're after.
I really want to hammer in on that point, because I think this is one of the things that even people who just sell media and advertising don't necessarily know, because they're used to selling, hey, I sell ad spots. I have my disclosure. It says it's a sponsored ad or a paid ad. When it's a security, you're saying that the actual specific compensation has to also be disclosed.
That's exactly right? It's the amount of compensation. So if it's dollars, how much money were you paid? If it's shares, how many shares were you paid, right? If it's warrants to purchase at some other price, what's the warrant, right? what is your compensation in whatever form it is, and sort of the way that using the SEC's language, direct or indirect, right? So you can't sort of structure it as, hey, we're going to funnel money to this other sort of related company for some related services, and really you're getting paid to publish it, to publish a recommendation. So yes, absolutely, you sort of need to specifically disclose the compensation.
Right. And so that like in this particular, so there's also, I guess, different types of securities, right? So we have the, public stocks. And in this case, we had, it was a Reg A product in security, or a crowdfunding security. What are the differences here in those two kind of entities or securities?
At the end of the day, a security is a security, and a lot of people tend to think the SEC, regulates the public markets, and therefore their rules only apply if we're talking about publicly traded stocks. And that's just not the case, right? If you and I open a company, ABC Corp, right, and we're selling shares to people who we want partners in the company, that's a security, right? And whether that's ever publicly traded or not, and you sort of have seen those issues recently, like with cryptocurrencies, right? And sort of all the ICOs that went on, and now everybody has learned about the Howey test, the Supreme Court opinion from 1946, that sort of looks at those investment opportunities and assesses whether or not those are securities. And it just is getting broader and broader. It got ridiculous this week when a case was filed where plaintiffs, not the SEC, but the civil plaintiffs, are filing against the maker of NFTs, of NBA highlight videos, right, which are effectively a digital trading card. And they've said, hey, this is a security too, right?
Right.
I don't agree with that. I don't think it's going to work out as well as plaintiffs had, but that tells you how broad it's becoming, right? And so in this, in the Makula case, the Reg A, all right, that's basically a private eye. It's a registered private offering, right? So it's not being invested. Stock isn't being sold to the general public on the market or whatnot. And so, it applies whether it's a private company, whether it's a public company, whether it's a public offering, whether it's a private offering, either way, to the extent that you're recommending or publishing a circular or any sort of recommendation for a particular security, and you've been paid, you need to disclose it.
Okay. And just for anyone who maybe has heard the term but maybe doesn't really understand what the Howey test is, could you just explain that just real quick, what the Howey test actually encompasses?
Basically what the Howey test, which was a Supreme Court opinion from 1946, it looks at an investment opportunity and to determine, because under the definition of a security under the SEC's main statutes, which are the Securities Act of 1933 and the Securities Exchange Act of 1934, which created the SEC. The definition of a security is a number of things, right? Stocks, bonds, and one of the things is investment contracts. And so what is an investment contract? It's really everything else. And what the Supreme Court sort of set up a test, right? If you're sort of an investment of money, generally pooling investor funds with other investors into a common enterprise, from which you hope to make a profit from the efforts of others, right? I'm a passive investor. I'm giving you my money and I'm going to sit back and hope that it grows. And that's effectively what the test is. So, when the crypto tokens come out, people said, oh, Bitcoin, it's not really security. It's really currency. Well, yeah, Bitcoin has sort of got to that level, but all these other coins are, you were sort of it might as well have been an IPO of initial shares of stock, right?
Right. So then anything then that essentially you say you have fractional ownership in, that you're putting money into, that is going to, you're putting money into because the hope of appreciating value, is basically a security, right? In that, like, the basic test.
Exactly right. Exactly right.
And so as a publisher, as a publisher, taking, like, it's one thing, like if I have a formal advertising process where it says, I'm taking money to sell an ad spot in my newsletter. I'm not recommending it, but I have an ad spot that's in there. I know now not to put a sponsored ad. That's not enough. I need to have a disclosure that says who paid me and how much they paid me. So if it's $10,000 for the ad spot, that actually has to be in the ad disclaimer. Then this issue with a staff member who is taking compensation, it seems to me that there's actually a lot more risk here than just to the publisher, where somebody is taking compensation for a security and then recommending it in a publishing business. Isn't the company, the one who is issuing the security, now paying for that promotion that is not disclaimed? And then if that publisher says things that they are not allowed to say as a security, is the company responsible for that?
The company certainly could be. If you get in the circumstances where the employee of the publisher has made some sort of a deal with the issuer, right, and has received shares or received other compensation, and is now sort of facilitating this advertisement, this recommendation in a newsletter somewhere, well, yeah, sort of the company's now is going to be on the hook, right? It's going to be responsible. They can't sort of stick their head in the sand and say, hey, what did we know, right? We didn't know he was going to do that, right? If there's no record that you knew he was going to do that, yeah, maybe you're fine, right? But you need to be concerned about that from an issuer's perspective, right? If I'm paying shares to somebody, what is their intention?
Right.
And if they're going to go promote the stock and we know that, then we need to address that.
And then what about publishers who they take the advertising, they correctly disclose compensation, but part of the advertising is that they're actually going to create it themselves. And so they're going to actually write up the promotion, the ad, or the content piece, or whatever it is, or create a video. What responsibilities do they then have when they start to create actual content and copy for a security?
So that's going to fall under sort of the SEC sort of fallback position on these disclosure cases too, is straight securities fraud, right? Which falls under Section 10B of the Securities Exchange Act of 1934, and so-called Rule 10b-5, as a lot of people are sort of somewhat familiar with. And 10b-5 has a couple of components, and usually, and the first one that's going to be applicable in this case is for misstatements, right? Any false or misleading statement of fact, materially false or misleading statement of fact or omission of a fact in connection with the purchase or sale of security. So if you have a publication that's recommending a security for purchase, that's in connection with this purchase or sale of security. And so you end up having securities fraud liability for any misstatements in that report. And so you have that's first step. And then when they can't get you under a misstatement because maybe you're not the one that actually made the report, but you were involved, but you didn't actually write it or you didn't actually publish it. The sort of fallback is the other two prongs of 10b-5 create what the SEC is called scheme liability, which is really just going to look at all your conduct, any collection of acts, and if they can manufacture a claim where it's designed to deceive somebody, it's going to fall into those other two categories of information under 10b-5. And so you're responsible for the content and ensuring that the content is accurate. And as a publisher, sometimes you don't know, right? Sometimes you're getting that information from the issuer, right? And so I always recommend to my publishing clients, you need to have an arrangement with the issuer where the issuer is going to review your publication before it goes out and sign off on it, right? And or identify, hey, here's the material facts we're going to talk about. Are these all true? Are they supportable? Are they public information? And that's sort of one of the things I do when I review my clients' publications when they go out. I can't go and fact check everything, right? You don't want to pay me outrageous lawyer rates to go fact check your publication, but I can go through and say, here's the 10 facts that I think a regulator that's like the SEC would deem to be material. And so those better be true, and those better be supportable, and go
Right.
out and find support for them.
Yeah. And then what about there's a something that a publisher normally doesn't have to worry about, is again, that is forward-looking statements. Like, what can you talk about what that is, and the risk there, and what, in understanding how to think about that piece?
Sure. And it's different depending on who it is that's doing the talking. If it's a publication that can actually be tied to the issuer, for example, if the issuer is paying for it, or the issuer is actually doing the publication, they have certain obligations to disclose forward-looking statements and have certain protections, that, hey, if we're just making projections into the future and we're wrong, that's okay. We have sort of a safe harbor. But from sort of the publisher's perspective, if statements are in there, and basically forward-looking statements are, if you look at the case law and the definitions, it's anything other than historical facts, right? So unless you're saying company did X, company did Y, company did Z, and instead are saying, we anticipate that they're going to do X, Y, or Z in the future, those are forward-looking statements. And, I caution my publishing clients is, you have to hedge those, right? That this could happen, that this may happen, that this might happen, that we expect this to happen, that the company projects this is going to happen, right? And use all those sort of trigger words, right?
Mm-hmm.
That shows you're not certain of this. This is absolutely not certain. And therefore, what you're trying to do is to turn it from a material fact, right? That it's not a statement of material fact, and therefore cannot be the basis for an SEC claim under 10b-5.
And so it'd be
misleading statement.
And so that's a super broad amount of things, though, because you're talking about, like, you make a prediction about where the stock's going to go. That's material. You make a prediction about revenue. You make a prediction about a mining company securing a piece of property that they have not yet secured. You say Warren Buffett is likely to invest in this business in the future. Like, you're making predictions about something that could happen. That's a forward-looking statement. Then now you're talking about, like, things that, like, let's say you like take that outrageous example. Warren Buffett, like, is going to talk. I think there's a good chance Warren Buffett could come into this investment. Is there a grade there? Like, hey, Warren Buffett actually looked at this investment and said he might, versus I've never had a conversation with Warren Buffett in my life. Like, there's a huge difference there in my liability with the same statement, right?
Yeah, you've hit it right on the head, really. You have protections for opinions, right? And as a newsletter writer, I'm offering my opinion about this stock, and my opinion is protected and doesn't have to be materially, factually true, because my opinion is basically a forward-looking statement. But I've got to have some basis for that opinion. Right.
Mm-hmm.
I can't look at a stock that's trading at 40 cents and say, oh my God, this thing's going to go through the roof, right? It's going to be $100 stock in no time, right? You're not going to be able to show a real basis for that opinion. Same with Warren Buffett, right? If you don't have any factual basis on which to conclude that Warren Buffett might be interested in that company, then you better not say Warren Buffett might, even if you safeguard it by using the word might or could. If you don't have any basis to go into that area, then stay out of it. Yeah.
And it seems so, like, the digital environment is way more complex than other mediums, right? Even in person, right? Because the places where you can put an ad, like, what if you have, like, an Instagram post, right? You can't put your disclaimer in the post per se. I guess you could in the comment. But how do you deal with that as an issuer? Because I feel like that area of advertising, like, this is a huge thesis of mine, that we're already seeing that, like, an increase in issuer advertising, just an explosion of it. But there's all these different ad formats. Where does the disclaimer have to be, and where is it okay for it not to be?
So the good recent example of that is the Kim Kardashian case, right? Who put on her Instagram post about some cryptocurrency. Hey, this is the greatest thing since sliced bread, right? But she had been paid $250,000 to do that, to put out that Instagram post,
Right.
and didn't say anywhere in it, right? So she's now become a publisher, all right? And so she's a publisher by putting out that post and recommending that somebody go buy this cryptocurrency, which I'm sure she had no idea was actually a security, but was paid to do it, and she needed to disclose it. Now, the cryptocurrency issuer who has paid her certainly should say, hey, you need to disclose that or whatnot, but ultimately it's not on the issuer. It's on the publisher. The requirement to disclose compensation received in exchange for recommending a security is on the publisher and not the issuer. And so if the issuer knows you're doing it and knows you're not going to disclose it, that's when they try to, SEC might try to squeeze you into that scheme liability. B5, A, and C, that, you know, you were sort of involved in your acts contributed to the public being deceived, even though the disclosure obligation was not yours.
Right. Right. That makes sense. I mean, are you seeing a rise in the types of media and publishing clients and like the number of cases around this issue? Because it seems to me like that's definitely like a trend now.
It certainly is. And I think with the advancement of, like you said, different media space, right? Now you have Facebook ads, right? Now you have Instagram posts, et cetera. You have all these sort of social media. And sometimes, you know, it's not just a full report or an article that's being put out there. It's you know, just a feed, you know, hey, click here, right? It's clickbait. Click here to get to the full report. And you know, at the end of the day, it's like you said, right? How do you put your full disclaimer or whatnot in this Facebook post that's this big? So, you know, in all likelihood, could you safely say link it to your article and your article has your disclaimer? Are you probably okay? Probably. Even though technically even your Facebook banner ad is really a recommendation of a security if you've worded it that way.
Right.
But if you can click through to it and get to the disclaimer to find out you've been paid, you know.
Especially if you have some kind of mention that there is compensation in somewhere in the post, or
certainly advisable, right? If publishers willing to do that, absolutely a good step. You know, and maybe that's the place where you say paid advertisement, right? And just leave it at that. And then when you click through, you have your full disclaimer.
Yeah. I think that's like, I mean, nobody wants to be the test case.
Right. Exactly right.
And so Kim K got to be the test case on one thing there, but like that seems like, because I see this already, like the lines are blurring between media in all aspects of financial capital markets everywhere, and things that seemed clear before seem less clear. Like I think like the other area that is starting to get confusing is the issue of general solicitation when somebody who has a fund also has a social presence. When does general solicitation, like, I guess first let's maybe touch on that. Like, what is general solicitation, and then see how that affects media.
So generally, general solicitation is sort of was traditionally prohibited in sort of raising money, right? That companies, unless they wanted to go through a full-fledged initial public offering and file registration statements to the S.E.C. and hire underwriters and go through the whole process, you could not market to the general public. You could only market your investment opportunity to people with whom you had some prior relationship. Then sort of with the advent of what's called sort of Reg A plus, right? They got to the point where the S.E.C. realized, hey, the little guy is never getting any of these opportunities, right? And is never getting, you know, mom, pa, you know, who only have $5,000 to invest and not $1 million to invest, are missing out on all these investment opportunities. And so under Reg A plus and Reg CF, which is crowdfunding, you can now, they're under certain conditions, do a general solicitation, meaning I'm going to advertise to the general public, even if I don't know anything about it. I don't know whether you're an accredited investor. I don't know how much money you make. We don't have any prior existing relationship. That's now a general solicitation, but there's certain, limits and regulations and restrictions around that, the information that the issuer needs to get about those investors, et cetera. But now it permits people to invest in sort of smaller pockets and hopefully get access to investment opportunities that they could not before that.
And now what about funds though? Like if I have let's say I have a real estate fund or a venture fund, and I have a social media presence, and then I have a link that says, hey, come invest in my fund. Like you still have to be a reg. I mean,
it's going to depend on how you're raising money, right? And if you're raising money through simply a private placement offer memorandum, right? Just give us your money. It's not a registered offering. There's going to be issues with respect to whether or not you can do a general solicitation under those. If you do general solicitation under all the requirements of Reg A plus and Reg C, I think you're going to be fine. But if you're just raising money on your own and now you want to do it through a general solicitation, you're going to have issues and you need to fall. I mean, there's certain limited amounts of money that you can raise through general solicitation, and there's certain of the former, we used to call Reg D, right? Various rules under which you can raise money privately, and some of those have to be accredited investors. Some of them you can have a limited number of non-credited investors, but most of those bar general solicitation. And so the general solicitation needs to be within the strict requirements of the new regulations.
That makes sense. So where do you think are the biggest, the biggest risks then on a publisher then is largely disclosure?
The two primary things are disclosure of compensation, and sort of a related issue is disclosing share ownership, right? And so even if you're not being paid in shares, but the publisher is a shareholder in that company, that's something that readers want to know. Right. So you say, hey, I haven't been paid to put out this publication. Right. So I have no disclosure to make there, but I'm a shareholder. Worse yet, I'm a shareholder who's going to sell to you when I've recommended that you buy, and now I'm selling into the demand that my promotion has created. Right. And it's sort of a practice called scalping, as the S.E.C calls it. And so, the fact that you own shares and or the fact that you intend to sell shares is going to be considered a material fact. It's not going to come under the disclosure obligations of 17B, but it will come within the S.E.C's Rule 10B, sort of securities fraud, right? And the S.E.C looks at it pretty simply, right? What would you want to know if you're a reader? And if you're reading that and you're claiming to be this unbiased person, and this is a unbiased newsletter writer, I think this is a great stock. And ultimately, you have some benefit, right? You have something to gain. That stock goes up because you own shares or warrants or whatnot. And that's when you also sort of need to have policies in effect that you know what your employees are doing, right? And so that you know if they are shareholders of the company. You don't have to say you can't. Easiest thing is to say you can't buy stock in any companies we're going to write about. But you don't have to do that. You can just say, hey, if anybody owns it, we better disclose that, some employees are shareholders.
Yeah. And I know a lot of publishers have rules too, where they're like, they can't buy or sell a security within 48 hours or 72 hours of a recommendation going out to do either. Things like that. If you're an employee, because they want to avoid the issue of being perceived as scalping.
Absolutely. In fact, I'd put it broader than 24 or 48 hours. I'd put it a minimum of a couple of weeks if you're associated with a publisher who's putting out a recommendation. I would wait until that campaign has stopped, and within any given recommendation, certainly I'd wait a couple.
Yeah, well, and a lot of those are like daily emails, so they do an email like a recommendation update to the portfolio. But that time frame, that seems very, very relevant to a lot of people. And I feel like a lot of the smaller publishers have more of the risk because they just don't have the capacity to have staff to help with compliance and things like that. So the owner has to be the one that understands this stuff, and knows what's possible or allowed and not allowed.
Exactly right. Very few publishers have either a general counsel or a compliance officer. And so it does fall on the shoulders of the owner of the business.
Yeah.
To get good outside counsel who can advise you on.
Yeah, no, absolutely. Are there any other major issues that you see, like as a something that publishers and people who are selling advertising into the security space should be aware of it these days? Or
at the end of the day, like I said, there tends to be these new twists every 5 to 10 years, right? A new twist on how they're being promoted and where they're being promoted. But ultimately, it all goes back, right? The S.E.C is relying on statutes that were written in 1933 and 1934, right? Because they think it's that broad. It comes back to the fundamentals, right? Disclose if you've been paid, disclose if you own shares, and don't make any misstatements, right? Don't make any misstatements or omit to state any facts that are material.
Yeah. And then you mentioned Bitcoin and crypto before. There has been this whole movement towards, like, there was a period of time when everyone was like, oh, these aren't securities. But then you're like, the Howey test. That's why it's like, well, according to the Howey test, this is like very much a security. And I think I've had this conversation with people who were like telling me, like, they were trying to get me to, and I didn't take it. They were trying to get me to take compensation in the form of like coins in order to promote them to my audience or something else. And I'm like, I'm not, like, I don't want any part of this with because my thing with, like, especially with crypto was but the argument for them was like, hey, this isn't a security. You don't have the same. And I'm like, I disagree. I disagree. And I suspect that the S.E.C at the time did too. And it's turned out that way. Like it seems to be moving in that direction very heavily.
That's exactly right. Yeah. In July of 2018, the S.E.C came out with what's called the Dow report, right? Which is where they were putting the market on notice that, hey, all these cryptocurrencies, we think they're securities. And they've been pretty consistent since that time period and taken the position that these are securities. I think, Bitcoin and Ethereum, have probably transitioned, right, into actually being a currency, right? Because you can simply use that and use it to buy and sell. You could buy a Tesla with it for a while there, right? So it actually probably got to the point where it's a currency and not an investment. But pretty much every other cryptocurrency out there is going to be, in the eyes of the S.E.C, for sure, a currency, a security.
Yeah. And have they brought a lot of cases around that at this point? People who are not treating it as a security?
Absolutely. Yeah. So they sort of put that report out in 2018, and then sort of from that period on, they sort of looked at that as, all right, you were on notice then. If you did things earlier before that, maybe you knew, maybe you didn't. So if you didn't commit out and out fraud, they probably had, they had enough actual fraudulent investments out there in the crypto space to go after, and they sort of left you alone. But if you raised money, even at a totally legitimate, no fraud, initial coin offering through a cryptocurrency, anytime after July 2018, the S.E.C says, hey, you knew, you were on notice, should have had good lawyers that put you on notice. And the S.E.C says that's part of the problem, right? These crypto companies weren't getting good legal advice.
Right.
Lawyers were saying, yeah, sure, we could do that. We could sort of shoehorn that in. It's not a security, and they just weren't getting good legal advice. And the S.E.C says, hey, you guys are the gatekeepers, right? If you're giving bad advice, your clients do bad things, right? And so we're going to hold you responsible too. So since then, there's been a lot of S.E.C actions in the cryptocurrency space.
Yeah, it definitely seems to be an area where there's a regulatory bull market.
Yeah, exactly right.
So, all right. Well, I appreciate this, Mike. Like, I think this has been super helpful. I hope everyone who's listening who has any interest or is already involved in anything related to investor relations, marketing securities directly, taking money for that, like, is aware of this stuff. And then I think that issue with employees, like, you need to be aware, and they need to be aware of what your policies are about that, and be very clear that this is, you can't take compensation under the table, and there are, like, the SEC is active. They're active in the space.
Yeah, exactly right. Yeah. From a publisher perspective, you want to be in a position where you can defend yourself when the SEC comes and says, hey, your employee owned stock, you didn't disclose that. You think, well, I've got this policy right here. It's a written policy. That employee had to acknowledge receipt of this policy, and the policy required that employee to tell me, and I didn't have actual knowledge that the employee did it. And so our publisher can use that as a defense and be off the hook.
Yeah.
But you sort of have to have those policies and procedures, and you have to follow those policies and procedures. Absolutely.
Yeah. And I think in that case, the Bakula case, I think that's one of the reasons that the publisher in question was not named directly themselves. I think it's because they had really solid policies, and that they were not involved in this, and they had stated this is not okay. And I think they covered things pretty well, and they were not I think they were probably outraged that it was happening when they found out.
Yeah, I think you're very right.
Yeah. So awesome. Well, thanks again, Mike. This has been super helpful.